Good afternoon and good morning for those who are not on the East Coast. My name is Rahmah Abdulaleem, and I'm the co-chair of the Religious Freedom Committee. Welcome to this webinar. We are pleased to present today's webinar, Separation Anxiety, Church, State, and Supreme Court Rulings, brought to you by the ABA section of Civil Rights and Social Justice. This webinar is part of CRSJ's commitment to highlighting and sharing updates on key civil and human rights issues through accessible public programming. To learn more about upcoming events, our on-demand programming, or other resources, please visit us at americanbar.org/CRSJ. We have a few housekeeping notes before we begin. Please submit your questions using the Q&A function, not the chat. We'll get to as many questions as time allows. If you don't see the Zoom controls along the bottom of your screen, such as chat, Q&A, or captions, try moving your mouse or tapping your screen. This program is not for CLE credit. This program is also being live streamed to CRSJ's YouTube channel, where you can watch immediately after the conclusion of today's program. A recording of this webinar, along with resources from the panelists, will be posted online soon and shared with all registrants. Please consider forwarding this to your interested colleagues to help us expand the reach of this important conversation. Let's get started. I'm pleased to introduce our panelists. Stephanie Barclay, Professor of Law, Georgetown Law School, and Faculty Co-Director, Georgetown Center for the Constitution, Georgetown Law School. Eric Baxter, Vice President and Senior Counsel, the Beckett Fund for Religious Liberty. Robert Reed Jr., Vice President, Legal Affairs, National Alliance for Public Charter Schools. And Camilla B. Taylor, Deputy Legal Director for Litigation, Lambda Legal. And your esteemed moderator today is Bettina Cross, Associate Director for Public Affairs and Religious Liberty, North American Division of Seventh-day Adventists, and the editor of Liberty Magazine. I'll turn it over to you, Bettina. Thank you.
Thank you so much, Rahmah, for that introduction. We have a lot to talk about today. For a religion docket that looked rather sparse at the beginning of this term, it certainly picked up steam when the court granted review in a trio of cases that have again seen the justices grappling with some challenging First Amendment religion clause issues and how these interface with other protected rights. So today I am delighted to be talking to these four distinguished panelists about three decisions. There was the per curiam decision in the Oklahoma statewide charter school case versus Drummond, the unanimous decision in Catholic Charities Bureau versus Wisconsin Labor and Industry Review Commission, and then there was the split decision in Mahmoud versus Taylor. So since we have a lot of territory to cover, we're going to take those cases consecutively in the order that they came down. So Robert, why don't you give us an overview of the charter school case? How did this case arise? What were the questions before the court?
Thank you so much, Bettina. I appreciate that. First and foremost, I just want to thank the ABA for the opportunity to participate on this panel with these great panelists, and of course with you as moderator, Bettina. I thought it might be helpful just to kind of briefly review the case history, starting kind of in the state court level in Oklahoma, and then transitioning to SCOTUS, as you mentioned, also discussing kind of the questions presented and the decision itself. So just to take it back, really 2 years ago now, for that matter, back in January of 2023, St. Isidore, right, applied to be a religious virtual charter school. They applied to the Oklahoma Virtual Charter School Board, which is the authorizer there in the state. And in June of that same year, 2023, the board approved the school on a vote of 3-2. Later that year in the fall, October 2023, Oklahoma Attorney General Drummond actually filed a writ of mandamus lawsuit directly with the Oklahoma Supreme Court challenging the constitutionality of the school's approval. Later, the following year, or kind of midway through the following year, June 2024, the Oklahoma Supreme Court issued its decision and ruled that the religious charter school was in fact unconstitutional on a vote of 6-1-1, And generally speaking, it ruled that, or it opined that because charter schools are in fact public schools, governmental entities, and for that matter, even state actors, they can therefore not be religious per Oklahoma law and the U.S. Constitution. They actually did not even address the free exercise analysis because of their conclusion that as a public school and as a governmental entity for U.S. constitutional purposes, there was no need to even address the free exercise analysis. So following that decision in the fall, October 2024, both the school and the board filed cert with SCOTUS. And in January of this year, January 24th, 2025, SCOTUS grants cert in the case. When it did so, it set it on a bit of an expedited calendar, right? So it set oral argument for April 30th. And notably, Justice Amy Coney Barrett recused herself from consideration of the case. As I mentioned, oral argument occurred on April 30th. It was scheduled for an hour, actually lasted about 2.5 hours. And just to give you a sense of the main arguments in the case, of course, St. Isidore and the board were arguing that the charter school is a privately created, privately operated entity, privately selected board of directors, and as such, when there's a generally available government benefit or program and you allow private actors to apply, you therefore cannot exclude private religious actors pursuant to the Trinity Lutheran trilogy of cases. On the other side, Oklahoma Attorney General Drummond, of course, argued that as public schools, as governmental entities, charter schools must abide by the U.S. Constitution's Establishment Clause and therefore cannot be religious. And in support of that, he noted, among other things, that in the 47 states that have charter school laws, they're all defined as public schools. They're created by state law, et cetera, et cetera. So that was April 30th. May 22nd of this year, SCOTUS issued a 4-4 decision. It was literally one sentence, and it effectively said something to the effect of, by vote of an equally divided court, the judgment below is affirmed. So it affirmed the Oklahoma Supreme Court decision. We obviously do not know what the vote breakdown is, but as you all, or most of you probably know, a 4-4 decision does not carry with it larger precedential value, but merely affirms the lower court's decision. And so in that way, at least from our position, we live to fight another day. So I will leave it at that.
Okay, so let's dig now a little deeper into some of the arguments that were made. Stephanie, Robert has mentioned this trio of cases, Trinity, starting with the 2017 case, Trinity Lutheran. Can you give us an overview of these 3 cases? What was the constitutional principle that the court has developed through these decisions?
Yes, and can you hear me okay?
Yes. Well, Eric, I'm going to throw that very same question to you.
Certainly, yes. Beginning just in the last 6 or 7 years, the court 3 times has addressed this question of when the government offers a public benefit, holding that it cannot discriminate against participants because of their religious beliefs. So funding going to private schools, private religious schools have an equal right to participate. Any program that gives funding to private individuals, people can participate regardless of their religious belief, or even if they're going to use it in ways that in some ways implicate religion. I think we have Stephanie back now, so I'll let her pick up from there. And
Yeah.
Stephanie, we can hear you. Yeah.
Apologies about that. Just want to make sure you can hear me. Okay, so in Trinity Lutheran in 2017, the court established the foundational principle that denying a religious organization access to public benefit solely because of its religious character violates the free exercise clause of the First Amendment. The court emphasized that the Constitution protects religious observers against unequal treatment even when that discrimination stems from well-intentioned efforts to maintain church-state separation. That decision recognized that true neutrality requires equal treatment, not religious exclusion. Then in Espinoza in 2020, the court expanded this framework by striking down state constitutional provisions that categorically barred religious schools from school choice programs. The court clarified that while government isn't required to subsidize private education, once they choose to do so, they can't exclude religious groups based on religious status. And then in Carson versus Macon in 2022, the court further expanded this doctrinal evolution by addressing religious use restrictions. The court held that once a state provides tuition assistance for private secular education, it can't exclude schools that provide religious instruction. This decision moved beyond mere status-based discrimination to protect religious organizations' right to operate according to their religious convictions while participating in public programs. So together, these cases establish that authentic religious neutrality requires equal treatment in the public square. They recognize that excluding religious organizations from generally available benefits, whether due to religious identity or their religious mission and use, that can and does constitute discrimination. This principle acknowledges that religious organizations contribute meaningfully to civic society and shouldn't face a choice between their religious character and equal participation in public life.
Thank you, Stephanie. And so, we have now coming to the fore the key question in the case. What is this charter school that was established? Camilla, can you help walk us through the arguments that were made? I mean, was this a private religious nonprofit created by private actors, controlled by a private board, or was it a state actor, thus barred by the Establishment Clause, barred by the Oklahoma Constitution from being under sectarian control?
Well, the Oklahoma Supreme Court determined, to answer your last question first, that it was indeed a state actor, and that's a question of state law. And what I think was evident from the oral arguments at the Supreme Court was that several justices were very concerned about the degree of entanglement of religion that the state would be involved in if it were actually operating a religious charter school that would inculcate religion as part of its mission and its mandate. And those who asked those sorts of questions included Chief Justice Roberts. We don't know how the justices voted in their one-line opinion, but we know that he expressed concern about this particular question, and he distinguished past cases, including presumably Trinity Lutheran, by talking about how that was only a discrete involvement with religion as opposed to the operation of a religious charter school.
So, Robert, do you want to add to that?
Yeah, no, the matter in the case is whether charters are public, right, or private. Public governmental entities must abide by the U.S. Constitution Establishment Clause. The private entities obviously receive the benefit of the free exercise protection. And I think particularly Attorney General Drummond, through Greg Garr, who's a lawyer, really did a great job of elucidating that point that we are, in fact, the governmental entities, right? And why? For a variety of reasons. One, we're created by the state, right? Charters would not exist but for the state. They're defined as public schools in every state charter school statute. They're authorized by state agencies or state empowered agencies. They have to abide by similar state assessments as traditional district-run schools and the like. And so the analysis that we actually, one, do not even need to get to the private entity analysis because it's pretty well settled that in the 30 plus years they've been in existence, they've always been defined as public or governmental entities for U.S. constitutional purposes. In fact, and just to kind of take that a step further, it's almost unnecessary to even kind of delve into the state actor analysis for that matter, right? The state actor analysis only really applies, right, when you're trying to determine if a private entity should be considered a state actor. The position of Attorney General Drummond, the one we supported as well in the case, is that you don't even need to get to that because we are well established as public governmental entities and therefore cannot be religious per the Establishment Clause.
So, Eric or Stephanie, how did how did the other side make their argument that these chartered schools were in fact private entities? You know, does the fact that the schools are receiving public funding, that they have a contract with the government, does this necessarily transform them into a government or state actor?
Eric, do you want to go first and then I can jump in?
Sure, I'll just throw out that, the very purpose of these charter schools is to turn over the management of schools and the instruction in schools to private hands. And that's the very point of a charter school. And so when you open up a program and you allow pretty much any other organization to come in and say, oh, we'll have a charter school that's focused on environmental education. We'll have a charter school that's focused on Greek history and culture. We'll have a charter school that's focused on a number of different ideologies. Then the counter argument is that, well, if you have an organization that wants to come in and have a religious background to its instruction, that's just participating in this publicly available program like any other entity and shouldn't be discriminated against because of its religion. And in no other context has the court held that simply contracting with the government or receiving public funding makes you a government actor subject to First Amendment prohibitions. And so that would, you can imagine there are millions of entities across the United States that receive government funding, that contract with governments, and they don't become government actors just by those facts alone.
And just to add to that, the Supreme Court, in its unanimous decision recently in Fulton, was dealing with a religious agency that was providing foster care services. And, there was sort of an argument in that case that was made, at least subtly, that because that organization received a contract with the government, they should have to basically operate like the government. And the Supreme Court already unanimously rejected that sort of approach. There are constitutional reasons why, but the practical implications Eric talks about, I think, are important, that you could never have religious groups provide charitable services in partnership with the government anymore if that was the rule. So there's no world in which I think it was likely that that was going to be the rule on which the court would exclude charter schools. Now they might ultimately, in that case, like you can imagine Chief Justice Roberts being concerned about how much control in this case does Oklahoma have over these schools that's different than mere funding, that's different than mere contracting. At some point, enough oversight and control starts to look like it is an arm of the state and not just a private entity. And that's really the more important question that I think will arise in these sorts of cases. It will be a state by state specific question. It will depend on the charter school regime and laws in a particular state.
So clearly this issue is not going away in a hurry. It is likely to return in one form or another. So Robert, why don't you outline for us from your perspective, where would a ruling by SCOTUS deeming charters private entities, not public or governmental entities, how would you see that as impacting the charter school landscape nationally?
Great question. Thank you for that. I think our concern was really multi-tiered in that way. And so let me start with kind of the practical, kind of operational concerns, and then I'll transition into a few others. So if SCOTUS had deemed public charter schools private actors and private entities instead of public governmental entities for U.S. constitutional purposes, it's likely that state constitutions would also likely do the same, right? Deem them as private actors as opposed to public actors, public schools. And our concern, particularly around that point, addresses the per pupil funding, right, that public charter schools receive, just like district-run schools, right? And that per pupil funding under education clauses of state constitutions is expressly and exclusively devoted to the support of the public school system in a given state. So that to the extent to which charters are then deemed private, their access to that per pupil funding would definitely be at jeopardy and at risk. So that's a huge operational concern. Related concerns to that is charters' ability to get bonds, right? They use a lot of bonds, right, particularly for facilities, and the degree to which bond issuers may just have a reluctance, right, to issue bonds because they're worried about charters' ability to pay back those bonds if they don't have access to the traditional line of per pupil funding that they typically get. That's just another operational concern. In addition to that, there would be questions about teachers' participation in state pension plans, state healthcare plans, right? So those are huge operational concerns. Outside of that, right, we're also concerned about the loss of students' federal constitutional rights, right? Students, when they enter the doors of public schools, carry with them certain federal constitutional rights that don't exist in private schools, right? And so that's another huge concern with deeming public charter schools private. And again, as I mentioned earlier, because it's a 4-4 decision, we're certainly expecting this issue to surface again, but we hope that folks truly understand that a decision deeming charters private would fundamentally and drastically alter the way they've always been operated, funded, and governed.
Now, we have a couple more cases to get to, so we need to probably move on. But before we do, did anyone want to respond to what Robert just said, or shall we move on? Go, Camilla.
I'd also like to respond to the question in the Q&A as well, which is adding on to Robert's last point about the rights of students to be free from discrimination. In both Trinity Lutheran and in Fulton, the court was very careful to note in those cases where we were talking about public funding, for example, for a grant for playground resurfacing in Missouri, which is the Trinity Lutheran example. The court was very careful to note that there was no evidence in the record to suggest that that school discriminated in any way or was intending to use this public funding for any religious purpose. So there are big implications, just as Robert notes. And the important thing, same with Fulton, the court noted there was no evidence that Catholic Charities in that case discriminated against same-sex couples or against LGBTQ youth in its care. So that point is something that obviously the court has been very careful to note in deciding that certain types of funding are permissible under the Constitution.
Okay,
One
so
brief addition
ahead.
to that is that there's nothing in the record that suggests that the charter school in Drummond would have discriminated either. And in Carson, the court did say that the religious organization was going to use the funds for religious use. And that was part of the record on which the court ruled for the religious organization.
So let's move on to the next case. But remember, if you have questions about what you've been listening to, please put them in the Q&A. We will get to them at the end. So the next case is Catholic Charities Bureau versus Wisconsin Labor and Industry Review Commission. Stephanie, why don't you give us an overview of what this case was about, how it arose, what were the questions before the court?
Sure. Yeah, this is a unanimous case that came out of the Supreme Court this term. And what happened was that in Wisconsin, basically the court was striking down Wisconsin's interpretation of its religious exemption from unemployment compensation tax, finding that it violated the First Amendment by discriminating between religious groups based on theological approaches to their charitable work. So the factual background is that Catholic Charities, the social ministry arm of the Roman Catholic Diocese of Superior, Wisconsin, along with 4 subsidiaries, provide charitable services, including employment assistance for individuals with disabilities and daily living services for those with developmental or mental health issues. So importantly, Catholic Charities follows Catholic doctrine that prohibits misusing works of charity for purposes of proselytism and requires serving people without making distinctions about race, sex, or religion. That's an important tenet of the Catholic faith. So the issue was that because the Catholic Church, or the Catholic organization in this case, was making that sort of theological commitment, it was on that basis that they were being excluded from this religious exemption. So the Wisconsin Supreme Court had this problematic 2-part test where they essentially said that if you were, in order to count as being operated for a primary religious purpose, then you have to imbue the program participants with your Catholic faith, do things like use religious materials or proselytize. And because the court concluded that the petitioner's activities did not do those things, the state court defined them as not religious because these sorts of services could have been provided by secular entities as well, they said. And the court suggested that Catholic Charities would qualify if they had been doing teachings and evangelism and worship, but not otherwise. So in an opinion written by Justice Sotomayor, the court said that that was an inappropriate type of discrimination based on theological distinctions. So Justice Sotomayor said Wisconsin's exemption, as interpreted by its court, grants a denominational preference by explicitly differentiating between religions based on their theological practices, end quote. And that's something that our Constitution strictly prohibits. The theological catch-22 is that they could have received the exemption if they were making a different theological sort of commitment. Justice Sotomayor also said, quote, the clearest command of the Establishment Clause is that the government may not officially prefer one religious denomination over another, end quote, and that this type of discrimination then would be subject to strict scrutiny. So the court, in their strict scrutiny analysis, found that Wisconsin failed pretty handily. They didn't have any sort of uh, evidence that the Catholic Charity program of providing other sorts of employment benefits to its employees was insufficient. There was a lot of lack of narrow tailoring to explain why drawing its employment benefits program along theological lines was the best way to administer that program, and that there was massive under-inclusiveness. Wisconsin exempts over 40 forms of employment from its employment compensation program. Those exemptions cover other religious entities that provide charitable services in a similar manner. They're exempt. There's no good reason why Catholic Charities couldn't be exempt too. And in fact, the type of rule that every other state and the federal government employs that offers this sort of exemption avoids unnecessarily entanglement and is more protective while still meeting employment benefit demands for these employees. And so at bottom, the court said there was just a really poor fit between the state's asserted interests and the line that it had drawn. And so the court unanimously ruled against the government in that case.
Thanks so much, Stephanie. Camilla, Wisconsin clearly brought its own arguments to the court. And one of those was, as Stephanie has pointed out, that CCB was not operated primarily for religious purposes. Was this a good argument? Was this something that the court should have recognized? What were your thoughts on that?
Well, the question was really the interpretation of a statute that the Wisconsin Supreme Court interpreted as requiring the state to look into the particular religious motivations of the entity that's seeking the exemption. And that was the problem, because the test that the Wisconsin Supreme Court applied looked into whether there was an intent to proselytize, and it turned on that rather than on whether it was operating a secular program in a secular manner. So the issue was really a narrow one, where the problem was inquiring into the religious purpose or the religious motivation of the denomination and making a distinction based on that, based on whether there was proselytization, for example, or what the particular motivation was behind the decision not to hire only co-religionists, as Catholic Charities did. So that was the problem. Essentially, a pretty narrow narrow outcome.
You know, I don't know if I'm focusing or reading the tea leaves a little bit too closely here, but Justice Sotomayor, when she applied the strict scrutiny test, she used the phrase closely fitted in place of narrowly tailored. Am I reading too much into that? Is there new doctrinal ground being broken there in terms of how the strict scrutiny standard is being applied? Eric, maybe you have some thoughts on that.
Yeah, I don't think so. I think Justice Sotomayor was just trying to apply standard doctrine, and there was a clear result here. But I would push back a little bit on the narrowness of the decision, because there are a lot of cases out there, a lot of religious exemptions, for example. These, if you remember, going back to the HHS contraception mandate, several states have insurance mandates where they require all employers to cover abortions in their insurance plans. And a lot of the religious exemptions in those laws exempt religions that focus on proselytization, that only hire and serve their own members. So a very similar kind of line drawing. And so all of those exemptions now we know are inappropriate under the free exercise clause. In fact, the court had before it New York's law abortion mandate law, and it granted a cert petition in that case, reversed the New York Supreme Court of Appeals decision, and remanded back to New York under the Wisconsin case to say that that type of an exemption is no longer permissible. So I think there is a broader implication and an understanding that courts have to do a better job in construing religious exemptions to make sure that they're not drawing distinctions along theological lines or denominational lines.
Stephanie, did you have more to add to that?
I had some thoughts about Justice Thomas's concurrence, but I can wait until whenever you want to discuss that.
Which is right now. That was my next question, because it was an interesting concurrence dealing with church autonomy. What was your response to that?
Yeah, I thought he had a powerful concurrence where he was emphasizing that there was another ground on which the state could have lost this case, and that was that they should have deferred to the Catholic Church's own understanding that Catholic Charities are an arm of the diocese rather than a separate entity, and give more deference to how a religious organization needs to conduct its operations internally. And I think that concurrence will likely prove influential. I think this is an area where to watch to see how the court develops the doctrine of church autonomy, something that it has already developed in the context of the ministerial exception, but I think there's a lot more richness and interesting questions in that space.
It does raise some very interesting questions. So let's move on to the next case. But before we do, what are some practical takeaways from this case for attorneys who may be advising religious institutions on tax exemptions, state tax exemptions? Are there any sort of core ideas or principles that they should keep in mind?
I think that the court emphasized the fact that if the government is making distinctions based on some justification that just happens to incidentally affect religion, that's different than if the government is drawing distinctions that are based on theological points or other sorts of denominational points or religious points. And so if I was advising religious organizations, I'd say the latter type of distinctions are vulnerable and unlikely to pass constitutional muster. But if it's the first type of distinction, then there's just going to be questions about, if the government's saying we have to make this distinction because this is the necessary way to advance this particular public policy. That's fair game for the government to make those sorts of arguments. Then the types of questions religious organizations can ask on pro bono is, well, is that true? Is that really the best way to advance that policy? Are there better ways that you could advance that policy and still include us? But that's a different type of question and issue than the one that was going on in Catholic Charities.
Eric, anything to follow up on that?
No, I think that's great.
Okay, so moving on to Mahmoud versus Taylor. A 6-3 decision. Eric, you appeared for the petitioners in oral argument for this. So give us the summary of the facts of the case, questions presented.
This case arose after Montgomery County Public Schools, the Maryland community that's just outside of Washington, D.C., introduced what it called LGBTQ+ inclusivity curriculum for kids in pre-K through 5th grade. These were storybooks, one of them called Pride Puppy, that introduces to children as young as 3 or 4 to concepts that you might see in a Pride Parade, drag queens and drag queens, LGBTQ advocacy, and so forth. Other books dealt with gender transitioning. One of the books, a boy called Penelope, about a boy who identifies as a girl and goes through the story and persuades his family that he is really a girl. And the theme of the story is that the child should decide for themselves. Teachers were instructed to tell students that doctors guessed at your sex when you were born, and you should explore those things for yourself. Some of the other books introduce the idea that pronouns should change depending upon how you feel, not just according to your gender. One of the books about how you feel multiple times a day. You can change your pronouns based on whether you're feeling energetic or athletic or depressed or sporty. And so these were books that a lot of parents had concerns about concepts being introduced to their children at a young age before they were able to really process what these concepts mean. A large community of Muslim, Ethiopian Orthodox, Catholic, Jewish, and other parents began protesting under Montgomery County's policies, which rightly very generously allowed for students to opt out of any instruction that would violate their religious beliefs. That's been in place for over a decade in Montgomery County. Many parents started opting their children out, and to its credit, the board allowed those opt-outs for the first year of instruction. But then kind of abruptly at the end of the first year, it just announced that it would no longer notify parents when the storybooks were being read, and that it would no longer allow them to opt their children out if they found out. That raised a lot of concern. We represented a coalition of several hundred parents who just wanted the right to opt out. They were not challenging the curriculum itself or the presence of the books in the school, but simply seeking a restoration of the opt-out right. This implicated a over 50-year-old decision by the Supreme Court in Wisconsin versus Yoder, where the Supreme Court held that Amish parents had the right to withdraw their children from high school entirely, despite Wisconsin state mandatory education laws, and that because those parents had Amish had a proven track record of making sure that their children became productive citizens capable of providing for themselves and living in society, that there was no compelling interest in forcing them to continue attending school. That decision for over 50 years has been seen by the lower courts as kind of an Amish one-off based on the unique facts of that case. And so courts have consistently denied parental opt-outs in other contexts. So this was the first time the Supreme Court's had the opportunity to address that issue. And it really did reinvigorate Yoder as a important principle, a precedent of the court upholding parental rights in the educational context. The court noted that the right of parents to direct the religious education of their children does not exist only at home, but that it follows the child, including into the public schools, and that this is an important, Yoder is an important free exercise principle that applies in multiple contexts. The court also decided the case outside of the Smith rubric. So traditionally, when you have a free exercise claim, you're looking to show that a law is not neutral or generally applicable before you can challenge it under the free exercise clause. And the court, relying on Smith itself, said that these types of decisions, Yoder was one of the, in Smith, the court held, fell outside of that rubric. And once the parents assert a burden on their religion in schools, or government actors have the obligation to show that they have no other way to meet their purposes. And so it's a very important decision. I think it will be read in textbooks going forward for many decades, and we'll begin to see it play out in other parental right contexts as well.
So Camilla, I mean, as you're listening to this, clearly this issue of what constitutes a significant burden on religion, this was a disputed issue. How did the Fourth Circuit decide that? And how did that differ from how the court ultimately came down on that issue? This idea of how to assess what is and isn't a constitutionally significant burden on religion.
The Fourth Circuit was a 2-to-1 decision that relied significantly on the very threadbare record in holding that there was no evidence of a significant or even a minimal burden on the religious exercise of these parents. That was very fact dependent based on this record. I don't disagree actually with Eric that the Alito opinion for the majority in Mahmoud does seem to carve out a particular type of case where strict scrutiny under free exercise claims would be appropriate. And he relies heavily on the fact that the children could be very young here. Unlike Yoder, which seemed to rely equally on the presence of a fundamental right to parental autonomy in seeking the ability to exempt children from a state law. This is solely a free exercise claim, but it seems to say that there's a special character of a burden present when there's coercion present for very young children in a school setting, and that coerces children in a particularly religious way. There are also ways in which this case seems to be cabined in some ways, because although the court acknowledges that there is a compelling interest in having a safe and conducive learning environment that for schools to try to be creating for students, because of the history of past opt-outs that the school had given, plus the fact that the school under Maryland law gives an opt-out for certain sexual education curriculum, that no opt-out policy in this context was not necessary to achieve that compelling interest. So there are a number of factors that are very kind of specific to this case. It's one of a series of cases where the Supreme Court recently has decided in a way that has been unfavorable to either LGBTQ litigants, or in this case, the students in the school who do not wish to be stigmatized or discriminated against by having other students walk out simply because the existence of LGBTQ people is mentioned by a teacher. This is one of a series of cases where, despite the outcome being unfavorable to LGBTQ people, the court is very careful to cabin the case in a way that's specific to very unique facts, such that it is not likely to have broader doctrinal implications.
Fascinating. So what do you think, Stephanie or Eric? Has the court cabined its decision in this case, or are there principles here that will have broader reach going forward?
I think this is a huge case. I don't think it's going to be a really narrow one. The fact that the court decided this case on Yoder and not by doing the normal neutrality or general applicability analysis took a significant bite out of Smith, and the extent of the size is yet to be seen. But what this means is that parents can now bring a free exercise claim and go right to strict scrutiny when they face a burden on their religious upbringing without the court asking the complicated questions about neutrality and general applicability. And it's not just limited to this particular school, and it's not limited just to this particular context. The court did speak broadly about religious upbringing as a right that is exempted from the Smith framework, and that's a big deal. I also think that it was important that the court was, when it came to strict scrutiny, the government tried to make arguments that, well, it might be difficult to have students opted out because we've sort of woven this curriculum throughout the day. It relates to what Camilla was saying, so difficult for students to be popping in and out. And the court said, yeah, but you designed it that way. You could have designed the curriculum such that you had inclusive school books at a certain time of day. So it's easy to give parents notice and easy to pull students out. And by the way, that's what every other school board in the entire country does. And the fact that you designed a program in a way that makes accommodations more difficult is a problem of your own making that will not help you satisfy strict scrutiny. It will increase the likelihood that you lose your case. And that's a big deal too for any sort of government program, not just in the school context, not just in the parental context, but that the court is saying, hey, government, if you on purpose design your program to make accommodations harder, that will count against you, not for you, under strict scrutiny, anywhere, anytime. That's a big deal.
I would also just like to push back a little bit on the idea that this is an anti-LGBTQ decision. In reality, it allows the schools to go forth and continue to teach the LGBTQ plus inclusivity curriculum. And it simply, and this might have been a very different case if, for example, the curriculum were truly focused on teaching kindness and inclusivity, including towards people of minority groups, as opposed to pushing a one-sided ideological perspective. Even the school board's own principals had written a letter. As far as the Threadbird record goes, we had extensive evidence about what the school board was telling teachers to teach. The principals themselves had written to the school board saying they thought these books were inappropriate because they were age inappropriate, they were ideological, they were dismissive of religious concerns. So there are lots of ways that schools can respond to this opinion that don't implicate or treat negatively any one group. And as far as kind of the age aspect of it, the court did note that this would always be a fact-intensive question, but it's not as simple as just saying, young children are more susceptible. The children in Yoder were high schoolers, and there was really no coercion. It was simply the nature of the environment that students would be exposed to ideas around careerism and competition that conflicted with their religious beliefs. And so I think it's more of a fact-intensive situation where you'll be looking at the specific religious beliefs, the nature of the educational environment, and the nature of the instruction. And it's really an opportunity. I hope that schools will see this as an opportunity to respond more to the needs of their community. It really is a reminder that schools are there to serve parents, that they are the government and they are restricted by the First Amendment to respect the religious and other rights of parents. And this is an excellent opportunity for schools to recalibrate and stop seeing themselves, as some school districts do, as an opportunity to impose a certain kind of viewpoint on the population.
So Camilla, I want to give you a chance to respond if you want to respond to any of what's been raised. And I want to come back to a number of points that you made, Stephanie, as well. But also address for us, if you will, this idea of administrative workability, because this really was a focus of the dissent. What are the practical difficulties, challenges for school districts who are trying to accommodate opt-outs?
I'm certainly interested in hearing what Robert has to say about that as well. But yes, the dissent identifies the possibility that this could become a nightmare for schools if there are opt-outs now for people who wish to express a religious objection to any scientific teaching that suggests that the earth is round or is older than 6,000 years old, or any particular teachings about the role of women in society, that those might warrant opt-outs now too, because people may claim a burden on their free exercise as a result of their students hearing those messages. So there are certainly potential implications if you read this decision as not being cabined in the way that I suggest that it is. And I do disagree with Eric about the notion that there's some sort of ideological coercion or viewpoint about the message that transgender people exist and warrant respect, and same with gay people. That said, I do find myself agreeing with Eric that this school really has nothing to say about the ability, this decision rather has nothing to say about the ability of schools to incorporate inclusive curricula. And it is exclusively a decision about opt-outs and about what's required when people claim a free exercise objection to the teaching of the school district. And that is a fact-intensive inquiry that involves not only consideration of the age of the students, but also the history of the school district in allowing opt-outs for other purposes, because that was something that the majority relied on a great deal in finding that the no opt-out policy in Maryland was not necessary to serve the school's compelling interest in a safe and conducive learning environment.
So Eric, what do you think? Are there limiting principles to these opt-outs? Did the court identify limiting principles, or does it sort of open up the field, as Camilla suggests, for any kind of opt-out? And I'm also interested if you can also address the issue of, does it support the idea of non-religious bases for opt-outs?
Yeah, I think even the examples that were given, the idea that, flat earthers are going to use this. I mean, most school districts, including Montgomery County itself, have very broad opt-out policies and have for decades. And you don't see these kinds of issues coming up. And if there is the one-off person who doesn't want their student to learn about evolution, it's not that hard, um, to accommodate them. And in fact, we allow students to avoid all kinds of education by opting to take, calculus instead of advanced biology, and so the idea that we have to have some kind of a uniform system, it just does not track with the way schools are run today, where we work really hard to accommodate individual needs of students, and the reality that where there are very broad, states like Hawaii, Arizona have opt-out policies that say anything that you find controversial, you can opt out of. And you don't see parents raising these types of objections. So I think that the administrability concern is just not a reality. And then I think your other question was, what about non-religious parents? And I think, first of all, the First Amendment is first for some reasons. Religious rights often lead the way and protect rights in a lot of contexts. It would be very unusual for a school to say, oh, we're only going to protect the rights of religious parents and we're going to deny the rights of non-religious parents. And there are also other provisions, a number of ways that have been suggested in the Free Speech Clause, under substantive due process, under the Privileges and Immunities Clause, where certainly the right of parents would be protected in those contexts as well. So it would be shocking to me if schools really tried to make that type of a distinction.
Is the court, Eric or Stephanie or Camilla, is the court approaching the idea of a sort of a parental rights doctrine that's sort of grounded in substantive due process? Is that what we're seeing the court moving toward?
I don't think so. I think this is a parental rights that is rooted in the free exercise clause. So, as Eric points out, that might then, once schools figure out that it's really easy to accommodate religious parents, be a really good reason that schools choose to provide other opt-outs. And again, most schools in the country already do, not just for religious parents. But in terms of like bringing a constitutional claim, the court pretty clearly rooted this in free exercise basis. And I think it's just a much bigger question. Would they ever expand that to substantive due process? There's already some parental rights in substantive due process, but would they expand this sort of being able to opt out from school principals for non-religious reasons in substantive due process? I think I'm not sure if they would or not. I think that's a much harder question, more difficult to predict.
In fact, the court, on a number of looking at its past precedents, we've gotten used to thinking of Pierce and Meyer as substantive due process cases, and the court really said these are rooted in have roots in the First Amendment free exercise clause. We've gotten used to speaking of Barnett as a free speech case, even though it was presented to the court as a free exercise case, and the court reiterated that it was in fact a free exercise case. So I think on a number of fronts, the court was reiterating how strongly the right is protected under the free exercise clause, but I don't see any reason to be fearful for parents who have similar concerns for non-religious reasons.
I want to jump back to something that Stephanie raised earlier. Camilla, the majority, what was notable about the decision here, the majority sidestepped the 1990 Employment Division versus Smith. The court declined to overrule it, as it did in Fulton. But do you think that this decision in Mahmoud is serving to further erode the reach of Smith in these type of cases?
Well, it does establish a carve-out, a weird carve-out where strict scrutiny applies under these very unique factual circumstances. And while the court eschewed hybrid rights doctrine in doing so, the court did point to a number of fundamental right to parental autonomy cases in reaching this result. So it does seem as though there's an overlay of a value for the parental involvement in the upbringing of young children that is considered an aspect of this particular free exercise right. That said, because of all of the ways in which the court is very careful to say that it's not interfering with the rights of schools to develop their own curriculum generally, and the court is also very careful to note this compelling interest, as I've mentioned before, that schools have in creating a safe learning environment. And the court doesn't dispute that these books would contribute to that. So I do think that there are ways in which school districts should feel confident going forward in making sure that their curriculum is inclusive, because there are, of course, other constitutional guarantees to think about too, like the right of students to be free from discrimination based on sexual orientation or gender identity or sex, and the free speech rights that students themselves have too, the right to be open about who they are, to be free from harassment and bullying. All of those are precedents that the court has affirmed very recently, including Mahanoy, where the court pointed out again that schools have an affirmative obligation to protect students from discrimination, harassment, and bullying based on identities. So again, a narrow decision that is exclusively about opt-outs in the context of a school district that had a history of providing multiple opt-outs for multiple purposes, just not for this.
Any response, Eric and Stephanie?
I would just add, I do think it has the inevitable effect of raising the question of what is Smith really about. I mean, this carve out was in Smith itself, of course, where the court was uncomfortable overturning Yoder and some of its other core decisions, and so it kind of used this hybrid rights language. Justice Alito gives a nod to that and says that was kind of like a label that was imposed on it. We don't really know what the court was thinking at the time, but it does raise the question: why does Smith impose this additional burden of neutrality and general applicability? And I think that's a question we already know that a number of justices have questioned the validity of Smith, and we think that this kind of reinforces the idea that Smith stands on a poor foundation.
So one other thing I'll add to that, and I agree with everything Eric said, is that I think this court, not totally unique to this court, it's true of other previous courts, but this court certainly, I think, has an approach where they often narrow a decision for some time before they formally overrule it. So you have decisions that will be dead on the books for a long time before they're formally overruled. Lemon was a case like that. So are cases like Bivens, where like everyone who's practicing at the Supreme Court knows that's essentially dead law. Just when is the court going to say it out loud so that the lower courts know that too? And I think we might be there with Smith at the Supreme Court level. I mean, a big bite like this out of Smith is certainly another step in that direction. I still think it will be valuable for the court to eventually make that clear so that lower courts aren't applying it in ways that provide unnecessary burdens for religious litigants. But I think this trend is significant in that way, that it transcends the particular facts of this case. And to what Camilla was saying about, the fact-specific nature of this case, I think that that's relevant to questions about how a court will then survive, or how a government will then survive strict scrutiny once we have bypassed Smith and gone to strict scrutiny. That will always be a very fact-specific question. But the fact that parents and parental upbringing is now a big bite out of Smith, I don't think that's a particularly fact-specific inquiry anymore. That's a significant narrowing, even as a formal matter, of the breadth of that test.
So how should we conceive of parental rights doctrine now, post Mahmoud? What has this case done to further articulate the court's position on parental rights? I mean, if you were advising parents who are interacting with their school boards, how would you define their constitutional rights in this regard?
I would highlight a couple of issues. One, that the rights follow the child. And so there's a lot of questions, where else does this extend? Obviously, within the school context, that parents have rights, but the government will also have obligations in other settings where it brings children in and maybe has some influence over issues that would affect their religious upbringing at the very least. And so questions about, I think the court will have to grapple with how far does that extend? I think it's also very significant, as has already been mentioned, that the court kind of said, this will go immediately to strict scrutiny, and it really puts the obligation on the government. To me, this is really just like a foundationally American principle that the government's role is limited, and that parents in particular have rights to control the religious upbringing of their children. And just because you participate in a government program or receive government benefits, it doesn't diminish the right of parents to ultimately say how and when their children are taught such core issues.
Okay,
I have something to add to that. We can move on if you want.
Please, no, go ahead.
Just very briefly, something else that I think was important about this case, and something that the court was rejecting from the Fourth Circuit, is the idea that parental rights that are following the child are only going to be triggered if the government is doing something like saying, you must teach your child X, or we're going to subject you to criminal fines. Like that would be a pretty direct burden on the parent, as opposed to, in this case, saying, we're exposing children to these sorts of books in the classroom, and if you don't like it, pull your kids out of school. The Fourth Circuit argument and the government's argument was, you still have choices. You can pull your kid out of school. We're not really directly burdening you. And the Supreme Court pretty clearly rejected that. And basically, if you're putting a parent between Scylla and Charybdis, where they have to choose between options that make their religious exercise, their religious upbringing very difficult or very costly, that still can qualify as a burden that then will trigger the strict scrutiny analysis. So that would be part of the advice I would give to parents in those contexts Eric referred to as well.
And so, Camilla, I want to give you a chance to respond to anything there, but also, can you address the issue of how you would advise school boards who are trying to design some constitutionally sound, inclusive post-Mahmoud curricula, and how, what are the principles that they should be keeping in mind?
Sure. So to answer that first, they should absolutely be trying to design inclusive curricula to make sure that all of the students who are required to go to public schools feel safe and feel as though they are respected and free from discrimination and harassment based on their identities. That's absolutely important. And they should look at their opt-outs. And if they are offering opt-outs to various other aspects of curriculum, then they need to think about whether they need to offer universal opt-outs with respect to other topics as well. I mean, with respect to the fundamental right to parental autonomy, the court dodged that question here. The court has also declined to take it up in the context of claims brought by parents seeking the right to access to certain types of medical care, for example, to treat gender dysphoria for their young people. And that right historically has been recognized not only in the context of school curricula and Meyer and Pierce and so on, the ability to direct the educational upbringing of your children, but it's also been recognized in the context of the ability to make medical decisions as well. And it's at its apex when those medical decisions are consistent with standards of care and with the wishes of the young people. So that remains something that the court could decide in the future.
Okay, so why don't we move now to some of the questions that we've gotten, unless Stephanie and Eric, you have something to add to what Camilla just said.
I would just make the point that this is a great opportunity for schools to really model what it means to live in a pluralistic society and move away from the idea that disagreement somehow is equal to harassment or bullying. That part of living in a pluralistic society with people with different beliefs on really important issues that are important to their identity and how they live their lives is accepting that we can disagree and still be civil and kind. We can choose to go different paths. And that's really, I think, what this court did here is there's an opportunity here for schools through the Democratic majority to make certain curricular decisions and still for other parents to opt out, and that we can all get along and respect one another as we make those different decisions.
Okay, so we had a question come up during this most recent discussion, strict scrutiny. The court in Mahmoud didn't address whether Yoder or Mahmoud in fact involved hybrid rights. So there was this whole discussion, of course, on the issue of whether we needed more, we needed a hybrid right to trigger strict scrutiny. It just said the two cases involve the same kind of burden. So going forward, how do we know what type of burden will trigger strict scrutiny? And what do we do with the fact that Yoder did not apply a strict scrutiny analysis?
I have thoughts on the second half of that question in particular. But I can defer to others who want to talk about the hybrid rights piece. I mean, I don't think this was a hybrid rights case, but Eric, do you want to talk about that more?
Yeah, I just think hybrid rights has always been, I mean, frankly, somewhat of a joke. Courts have not known what to do with it. Some courts have just dismissed it out of hand. Some have tried to make some sense of it. And so I think the court kind of very intentionally didn't try to explain it or reinforce it. And I think we should now look as hybrid rights as having been set aside as not the correct way to understand what happened in Yoder. We know at the very least that when you have the rights of parents in the public school setting, that will take you directly to strict scrutiny. And then I think it just leads us to the other question we've already discussed is how much does Smith really, how solid really is the foundation of Smith?
And then on the next question, like, did Yoder really apply strict scrutiny? I think it did. And I will give a caveat that at this point in the Supreme Court's precedent, it did often refer to strict scrutiny as a type of balancing. RFRA and our experience with that statute, the Religious Freedom Restoration Act, has taught us that strict scrutiny needn't necessarily be thought of as balancing. But in that case, the court does talk about the compelling interest Wisconsin has in providing education and preparing youth to be part of a productive citizenry. The court engages in narrow tailoring for this Amish case. They ask whether the compulsory education law was really narrowly tailored to achieve the state's interest. It points out that the Amish community had informal vocational education and practical training that were still adequately preparing children for their way of life, and that it was a really productive way of life. It wasn't contributing to crime or other sorts of issues in the country. And the court said that the government's interest in Yoder wasn't least restrictive means. The Amish were able to provide these alternative forms of education that accomplished the government's interests, which meant that the government's compulsory education laws weren't the least restrictive means of accomplishing its goals. So the fact that in Mahmoud we're applying strict scrutiny to the sort of parental rights, parental religious rearing case is of a piece and consistent with what was going on in Yoder. Notably in Yoder, the court didn't ever actually say that there is a compelling interest in the other thing the government was trying to argue, which is that preparing children to leaves their family or leaves their religious community is a compelling interest. I think if the court had to address that squarely, they might say today, that's not the type of interest that is permissible for strict scrutiny. Preparing children to leave their families isn't the type of thing that government gets to do because that runs into other parental rights. And so the government can't have a compelling interest in interfering with constitutional rights. Court hasn't said that. That's my guess, but that's an interesting unanswered question from Yoder.
I want to say, Robert, I know your interest is mainly in the charter school case, but do feel free to jump in on these Q&As as you wish. We have a fascinating question here. Where does the right of the student to have an accurate education take precedence over a parent's desire to limit their education based on their religious beliefs? That's framed in a very interesting way. Camilla, I don't know if you want to weigh in on that one first.
Well, historically, courts have deferred a great deal to local communities to set curricula. And cases in which students have asserted a right to an education have not always fared very well. I think that there are certainly contexts where students have right to certain information, or at least in the context of library books, for example, in the school library, there are limits that the Constitution establishes to school districts' ability to ban certain books based on their content. And there's a freedom to receive information that students have in that context, according to a plurality decision in PICO and a number of different circuit court decisions as well. I think there are much more established doctrines that protect students from certain types of discrimination and harassment in school settings. And Eric and I can argue about what may constitute discrimination in a particular context, but for schools to refuse to acknowledge students' identity or refuse to acknowledge that a student is transgender, for example, would be a big problem and would be discrimination. For a school to allow sex-based discrimination and harassment to occur against a student by other students would also constitute discrimination and would subject a school to liability.
I would just add that Yoder and to some extent Mahmoud both acknowledge that the state has some interest, right, in making sure that children are properly educated. In Yoder, they expressly kind of cast that in terms of like the ability to reason, read and write, and the ability to be a productive citizen. And if you think about how states treat that issue today, of course, they're required to allow homeschooling and private schooling, but they don't impose these really strict burdens that insist on a certain type of instruction in every one of those settings. We have Charlotte Mason schools and more highly structured schools. We have all kinds of structures of homeschooling. And we can see from that experience that most kids come to these experiences as productive citizens. And so and certainly every parent agrees that all children should be able to study in an environment where they're safe, where they're respected. But that is subject to the right of parents to kind of control on these types of issues and make sure that they have a say. I think that Mahmoud will have a significant role to play in the number of cases that are arising around the country about schools that are either encouraging or supporting gender transitioning without notifying parents. And I think that Mahmoud would clearly suggests that parents in those contexts have a right to be informed and to have a say in how their children are treated in these schools. It's ultimately the parents who have the final say and not the government on how to react to these types of issues.
Okay, here's another question. There's been some controversy over so-called liberated ethnic studies, which have a strong anti-Israel, anti-Semitic component while failing to teach about Jewish identity, anti-Semitism. Shouldn't Mahmoud provide a basis for Jewish students to be opted out of such harmful curricula? And I guess this touches on the question of how far the opt-out, what the limiting principles are of these opt-outs, according to Mahmoud.
Yeah, I'm happy. I do think that there would be right of parents to opt their children out in those situations. And it goes to my point that this really is an opinion that benefits parents of all political and religious or no religious belief at all. That ultimately they might have, parents who really want this curriculum in Montgomery County might have an issue in a different state where there's curriculum that violates their religious beliefs. And Mahmoud would give them the right to make those decisions for their own children.
Stephanie, any thoughts on that?
Yeah, particularly if this is just one class or a portion of a class in a day, yeah, and it's something that there's no reason for it to extend throughout the entire day. I think that's an easy opt-out. And so it goes to what Eric is saying. This is the type of accommodation that I think is the best of our American traditions.
Okay, here's another question that sort of takes that issue and takes it much further. What role do you think the religion at issue affects the decision? Meaning, do you think the analysis or result would have been different if the religions involved were less, quote, mainstream? And the questioner here cites the example of, say, Satanists instead of Catholics. How far do you think that would have changed the equation here in this case?
Well, remember that some of the parents in this case were Muslims. So, there's a stereotype that often these cases arise just with like Christian opposition to LGBTQ curriculum. But that wasn't true. There were many different types of religious groups that had that opposition in this case. So I don't think that question is relevant as long as we're talking about a real religion. Now, the Supreme Court hasn't provided a definition of religion as a constitutional matter. But is it possible that that sort of definition would exclude groups like Satanists? They just don't count as religious groups. It's possible. So that's a different, interesting question that law professors have, cut down lots of forests and trees to write articles about, but that is almost never relevant in real cases before the Supreme Court.
Okay, I'm going to go back. There was a question asked earlier. It's about the Catholic Charities case, so we're going to jump back there. How much of a role do you think the religion at issue affects the decisions? It's a similar question to what we've just had, meaning, do you think the analysis would have been different if the religion was less mainstream? I suspect it's the same questioner. They're wanting to understand how that equation would change in the Catholic Charities case. And I suspect your answer will be the same, Stephanie.
Yeah, I mean, again, Justice Sotomayor is writing this opinion and unanimously, and she's just not the type of justice who's the one to say, yes, I'm sympathetic here because it's Catholics, but I wouldn't be if it was Muslims. I don't think there's any sort of indication that that is plausible. It's just that happened to be the group that brought this case. But the court has often ruled in favor of Buddhists, Muslims, other groups in their religious liberty jurisprudence, and I think that's a good thing in our country.
But that really was the entire point of the CCB decision, is that you can't draw those types of lines based on religion. And that was one of the mistakes that courts made interpreting Yoder, is they said they kind of said the opposite, like, well, this only benefits minority, more insular religions. And the court in Mahmoud said, no, this would apply regardless of your religious beliefs. And that's, of course, really mandated by the free exercise and establishment clauses.
But it is interesting that these cases are dealing with historically recognized religions, Islam, Christianity in its various forms. We have, and a questioner here is raising the issue of the court's recent denial of cert in the Apache stronghold case, which of course dealt with the religious freedom rights of very much a religious minority. Do you see that as perhaps shoring up this idea that the court finds it easier to perhaps engage with religions that are historically recognized as religions, and less comfortable perhaps in protecting the rights of religious minorities whose beliefs fall outside the mainstream?
I do think that the court, there have been times in the court's history when it has not been as protective of religious minorities as it should have been. Smith is an example of that. So I have a forthcoming article with my co-author Matthew Crowder that looks at Justice O'Connor's Supreme Court papers, and concern about how much are we going to protect religious minorities was something that motivated the justices in that case to roll back religious exercise protections. Now, I will say that that sort of allegation that the court is less sympathetic to religious minorities is often leveled at justices who are described as conservative justices or justices appointed by Republicans. And I think something that is really interesting and I think really disappointing in this case is that the two justices who would have ruled in favor of the Western Apache were Justice Gorsuch and Justice Thomas. And they said these plaintiffs deserve their day in court. We need to protect their sacred site. We would protect it under the Religious Freedom Restoration Act. And the silence was deafening from Justice Kagan, Justice Sotomayor, and Justice Jackson, who didn't have a word to say to stand up for those religious minorities, and who I think many would think are the types of justices who would particularly care about that. So I think that that is something that is worth being concerned about. Why weren't they willing to stand up for those vulnerable minorities in that case? It's a question I think is worth wondering about for me.
And I will note, just for those interested, the Apache case is still alive. There's a motion for reconsideration asking the court to GVR, grant, vacate, and remand based on Mahmoud. Just like as in Mahmoud, there were children's rights at issues in Apache. These are the rights of young Native American girls to have their coming out ceremony, and the rights of parents there are highly implicated. And so I do think the court got it wrong in denying, but I think there could have been many other reasons beyond the religion that was at issue. And I think Stephanie's points kind of go to that.
I'm sorry that Robert has had to drop off the conversation, but because I have a question that goes back to the charter school case. And my question is, if a similar issue comes back before the court and the court rules that charters and charter school programs must be open to religious schools, do we now run into Establishment Clause problems as a state is involved in that sort of discretionary process of picking and choosing which religious schools it will offer a charter to? Is there a problem with it violating the idea of religious or neutrality between religions? I mean, it can't give a charter to every religious school. How does it pick and choose in a way that does not violate that idea of neutrality between religions?
So if at some point we were in a country where religious charter schools were permissible, or if states decided to make those permissible, as long as the reason that the state is picking and choosing is for reasons other than the religious denomination. So, this school provided a better facility for the children, or, lower tuition, or whatever it is that they're evaluating the schools on. That's fine. So there's lots of reasons why a government could pick and choose between religious schools or choose a secular school over a religious school. And that wouldn't implicate the Establishment Clause at all. That's the type of neutrality within funding that the Establishment Clause permits and that the Free Exercise Clause requires when the government is administering benefits and letting religious and non-religious groups compete on other non-religious criteria.
Camilla.
Well, the real Establishment Clause problem arises when the charter school that is religious in nature, that inculcates religious views, religious beliefs, is a state actor and public, and is considered, and it's government funded. And that's what the Oklahoma Supreme Court determined under Oklahoma law, that it was a state actor. And we look to Mahmoud, which determined that messages about the existence of LGBTQ people to elementary school students were normative in nature, and that there was the potential for reprimands of students who might disagree with those messages, and that was considered coercive and violation of those students' free exercise. So that tells us exactly what we need to know about the coercive nature of a public school that might try to inculcate certain religious beliefs to the exclusion of others.
Let me just say that I agree with Camilla that if it's a arm of the government, if it is in fact a state actor, then there are Establishment Clause issues that arise if the government is teaching any sort of religious doctrine in school. But the whole ancillary question, the whole antecedent question in the charter school cases is, are there ways in which states can administer their programs such that those who become a charter school are not a state actor, such that it's almost the equivalent of them receiving a voucher. They're receiving funding, they have minimal government oversight, and they aren't the government. It isn't a public school, and they aren't a public actor. And at that point, all of the Establishment Clause issues go away, which means that the real question in the charter school context is often at that antecedent step. Is there enough government oversight and involvement that this is a public actor, or is it more just like funding with minimal strings attached that it looks more like it's on the voucher side of the spectrum, in which case then the voucher neutrality funding rules apply?
So we have about 10 minutes left. I want to give each of you a few moments to reflect on the religion docket in its totality. Since we have been talking about schools, maybe if you're comfortable, give the Supreme Court a grade on how it has handled its religion docket this term, and reflect a little on the themes that you've seen emerge from the court's decisions, and how you would rate how the Supreme Court has dealt with those issues. Let's see, who would like to go first on that one? Camilla, do you want to lead us out?
Well, I'm disappointed, obviously. I think that there are ways that opponents of equality for LGBTQ people will try to leverage some of these decisions in order to justify greater public funding of either entities that choose to exclude and discriminate LGBTQ people, or choose to permit harassment of students who are LGBTQ to take place. And I think the court could have done a better job at making clear that discrimination is not permissible and would be detrimental to the safe and conducive learning environment that the court determined was there were compelling justifications for schools having those. That said, certainly there are ways that these decisions can be cabined and should be cabined, because the court was very clear that they were limited in nature. I just am concerned, and I think we need to be vigilant in order to make sure that these are not used then as a weapon to legitimize discrimination.
Stephanie, why don't you go next?
Sure. When it comes to the Catholic Charities case, I'd give the court top marks. I thought it was terrific that it was a unanimous decision, and I thought Justice Sotomayor spoke powerfully about many of these principles of it not being the government's role to decide theological issues and to discriminate between religious groups in the way that the government did. And I thought Justice Thomas's concurrence about church autonomy was helpful and instructive. Mahmoud is also a case that I would give top marks. I think that is a case that it's a common sense ruling exemplifying the best of our American constitutional tradition, finding workable solutions that allow people of different faiths and backgrounds to participate in public institutions without forcing them to choose between their beliefs and civic engagement. And as Camilla has noted, schools can still offer inclusive education while providing reasonable religious accommodations. Both are possible. The court just emphasized do both things if schools want to have that sort of curriculum. And I think that's a good thing. I'm disappointed that the court didn't take the Apache case. I hope that they still will offer something like a GVR in that case so that the Apache people can have relief, because if their sacred site is destroyed and given to a foreign mining company, that's a tragedy for them. It's a really bad deal for our country. On the St. Isidore decision, it was just a 4-4 deadlock decision. One thing I'll say about that is if the court was not going to rule for religious liberty for a case on the docket, that was a pretty benign way to do it, at least in terms of like broader religious liberty implications, because there was no opinion that was saying religious charter schools are never going to be an option or that set problematic precedent. And so I think that that's one of the least damaging ways for the charter school in that case to lose. I think that it's more likely in the future that instead of seeing another charter school case come up to the court, we'll see something else that deals with religious use of funds, sort of expanding on the Carson principles. There's already a case in Maine that is sort of like the Carson 2.0 case, dealing with the same government, the same sort of policies. The government has tweaked that some. This is a Beckett case, and it's called St. Dominic. So I think cases like that are already on the pipeline are cases where we're more likely to see the court grapple with these questions of ways in which it might want to expand or strengthen the principle of religious groups being able to compete on the same footing as other groups when it comes to government partnerships and government funding.
Eric.
Yeah, I would also give the court high marks. I think this is a court that is really working hard to root the religion clauses in history and tradition, trying to understand why they were first introduced into the Constitution, what were the principles of freedom that they were designed to protect. And so I think in these cases, you do see some careful thinking about what are the real origins of these rights. How do you harmonize the religion clauses instead of seeing the free exercise clause and the establishment clause in tension, recognizing that they were both enacted to protect freedom of religion and the right of people to choose their own religious path. Those are rights that protect all Americans, regardless of their faith. And so I do appreciate the court's efforts to root these rights in the underlying traditions of our Constitution. The freedom to make their own choices and such important aspects of their life. Also disappointed in the Apache, of course, and St. Isidore cases. I think St. Isidore may have been just an example of the court's incremental approach and kind of thinking about some of these issues very carefully and slowly. You know, there is a very strong public conception that charter schools are public, and there hasn't been a lot of thought into what that really means. Does slapping the label on it really mean anything, as opposed to how you're treating these schools? And so, if you listen to the justices, I think there were 5 justices in the oral argument who really saw the tension there, and so I think that issue is still a live one. I think Apache also, although it was very disappointing, and I would like to see the court recognize the right of the Apache in that case. I'm also hopeful that in the long run, these principles that are being established will eventually inure to the benefit of all Americans. So.
Thank you. Thank you, Eric, Camilla, Stephanie, for a really robust, really thoughtful conversation. I know Robert lost his internet and couldn't get back on. Thank you to Robert also. So back to you, Rahmah.
Thank you to our incredible moderator and panelists for sharing your insights, and to everyone who joined us live or on demand. Your participation and thoughtful questions are what make these conversations so impactful. If you found today's program valuable, we invite you to share today's recording with your networks and explore other upcoming programs at americanbar.org/CRSJ. To stay connected with our work and help shape the future of civil and human rights advocacy, we invite you to join the ABA in the section of Civil Rights and Social Justice. We look forward to continuing this important dialogue with you.